Okay, good morning, everyone.
Good morning.
Are we ready? All right. Thank you so much for being here. I am Clarissa Rodriguez, Chair of the New York State Workers' Compensation Board, and I call the 983rd meeting of the Board to order. Madam Secretary, will you please call attendance?
Vice Chair Foster.
Here.
Board Member Pembrowski.
Here.
Board Member Higgins.
Here.
Board Member Logan.
Here.
Board Member Williams.
Here.
Board Member Hall.
Here.
Board Member Osley.
Here.
Board Member Crane.
Here.
Board Member Stasko.
Here.
Board Member Taveras. Here. Board Member Cashinelli.
Here.
Board Member Delam.
Here.
All members are present.
Okay, thank you. Agenda item 1, approval of the November 19th, 2019 meeting minutes. You have all received a copy of the November meeting minutes for review. Are there any questions or need for discussion?
Move to accept.
Okay,
Second.
thank you. All in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 2, Office of General Counsel's Departmental Report. General Counsel David Wertheim will now present the statistical and informational report for November.
Thank you. Morning, Chair, Vice Chair, Board members, and colleagues. Here is a report for November 2019 where issues were resolved here at the Board. First, in adjudication, there were 17,142 hearings held, 11,015 cases fully resolved at the hearing, and 450 reserved decisions issued. There were 2,561 Section 32 waiver agreements finalized, 2,061 by hearing, and 500 through the desk process. In ARD, there were 962 applications for administrative review received, 909 processed, leaving an end-of-month inventory at 2,383. Full board review, there were 161 applications received, 163 processed, leaving an end-of-November inventory of 217. That concludes the report. Of course, I would take any questions.
Okay, may I have a motion to accept the report?
Motion to accept.
Thank you. All right, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 3, license applications. Elizabeth Lott from the Office of General Counsel will now present the licensing applications.
Good morning, Madam Chair,
Good morning.
Vice Chair, board members, colleagues. You have before you the recommendations from the assigned board panel regarding the license applications listed in Part 3 of today's agenda. Section 24A, Marilyn Brook, 3-year renewal. James Franz, 3-year renewal. Richard Feldstein, 3-year renewal. Mitchell Weiss, 3-year renewal. Angela Gucciardo, 3-year renewal. Domenica Gucciardo, 3-year renewal. Section 24.3B, CNA Claim Plus, 1-year renewal. Section 53-D, Claims Administration Services, Inc., 1-year initial application approved. And Veritas Administrators 2, LLC, 1-year renewal. I present these recommendations to the board for your consideration.
Okay, may I have a motion to accept the recommendations?
Motion to accept.
Okay, thank you. All in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 4, legal appeals. General Counsel David Wertheim will now present the recommendations concerning decisions by the Appellate Division.
Thank you again, Madam Chair. From the time of the last board meeting until now, there were 11 decisions issued by the Appellate Division 3rd Department with respect to workers' compensation claims. Of those 11 decisions, there were 4 affirmances, 1 modified decision, and 6 reversals. I have a 2-part recommendation today. First, with respect to items 4C, 4D, and 4E of the agenda. It's my recommendation that the board direct Office of General Counsel to request the Attorney General to file motions on the board's behalf to re-argue and/or for leave to appeal to the Court of Appeals in each of these 3 cases, which are Poulard versus Southside Hospital, Bowers versus New York City Transit Authority, and Mundy versus Verizon New York, Inc. With respect to items 4A, 4B, and 4F through 4K inclusive, it's the recommendation of General Counsel that all of those decisions of the court be adopted as the decisions of the board.
Move to
Okay.
accept the recommendations of General Counsel.
Thank you. Okay, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 5, mandatory full board review. 5A, Sachem CSD, case number 40603539. Is there a motion with respect to 5A on the agenda?
Yes, Madam Chair, I move that the opinion of the majority be adopted as the opinion of the full board.
Thank you. Is there a second? All right. Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5B, ABM, case number G2256749. Is there a motion with respect to 5B on the agenda?
Yes, Madam Chair, I move that the dissenting opinion be adopted as the opinion of the full board.
Okay, thank you. Are there any recusals in this matter? Is there any opposition to the motion?
Yes.
Okay. In light of the opposition, I call upon the secretary for a roll call vote.
Board Member Hall.
No.
Board Member Taveras.
Yes.
Board Member Stasko.
No.
Board Member Crane.
Yes.
Board Member Osling.
No.
Board Member Delon.
Yes.
Board Member Logan.
Yes.
Board Member Higgins.
Yes.
Board Member Paprocki.
Yes.
Board Member Williams.
Yes.
Board Member Cajanelli.
No.
Vice Chair Foster.
Yes.
Chair.
Yes.
That motion is carried 9-4.
Okay, thank you. 5C, Preferred Payment Systems Corporation, case number G0550499. Is there a motion with respect to 5C on the agenda?
Yes, Madam Chair, I move that the opinion of the majority be adopted as the opinion of the full board.
Okay, thank you. Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5D, Unity Health System, case number G2181892. Is there a motion with respect to 5D on the agenda?
Yes, Madam Chair, I move that the dissenting opinion be adopted as the opinion of the full board.
Okay, thank you. Are there any recusals in this matter?
Yes.
Okay,
Second.
all right, duly noted, thank you. Is there any opposition to the motion?
Yes.
Okay. In light of the opposition, I call upon the secretary for a roll call vote.
Board Member Paprocki.
No.
Board Member Logan.
Yes.
Board Member Williams.
Yes.
Board Member Higgins.
Yes.
Board Member Stasko.
Yes.
Board Member Delon.
Yes.
Board Member Taveras.
Yes.
Board Member Crane.
Yes.
Board Member Osley.
No.
Vice Chair Foster.
Yes.
Chair.
Yes.
That motion is carried 9-2.
Okay, thank you. 5E, Quest Diagnostics, case number G0684519. Is there a motion with respect to 5E on the agenda?
Yes, Madam Chair, I move that the board panel opinion be adopted as the opinion of the full board.
Okay, is there a second?
Second.
Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed, thank you. 5F, Shenango Valley CSD, case number G0910941. Is there a motion with respect to 5F on the agenda?
Yes, Madam Chair, I would move that the majority opinion be adopted as the opinion of the full board.
Okay, thank you. Are there any recusals? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed, thank you. Okay, that concludes our mandatories. There are no discretionary cases for full board review this month, so is there any other business? All right. Hearing no other business, agenda item 8, our guest speaker. This month, we welcome our departmental guest speaker, Mike Papa, Deputy Counsel for Compliance and Litigation here at the New York State Workers' Compensation Board. After graduating from Albany Law School in 1997, Mike briefly worked in the private practice, then served as an administrative law judge for the Department of Labor before joining the board. During his 19-year tenure here, Mike has held a number of senior roles within various divisions. These include Deputy General Counsel, as well as Special Counsel, during which he acted as the Director for the Litigation Division and protected the board's interest in all litigation affecting the agency. In his current position, Mike oversees all areas of compliance and continues to oversee the Litigation Division. Today, Mike will be speaking with us about the various matters the Litigation Division has handled this year. Welcome, Mike. Thank you so much for being here.
Thank you. Good morning, board members and fellow employees. Today I'll be talking about litigation involving the board. In addition to the group trust matters, Litigation Division handles numerous types of actions on behalf of the board, virtually all of which require a defensive posture in the sense that the board is defending the integrity of a prior board determination. In these matters, the board is represented by the Office of the Attorney General. However, due to the nuanced nature of the workers' compensation law, its intricacies are generally not well known by practitioners, and in that sense, litigation staff take a very active role in defending the suits. Litigation works hand in glove with AAGs to gather appropriate supporting documents from the applicable board unit, engages in discovery where appropriate, drafts supporting affidavits for personnel with first-hand knowledge of underlying facts, determines viable defenses, and reviews and proposes changes to accompanying memorandum of law. So litigation was involved in roughly 36 matters in 2019, and they can be grouped into 5 broad categories. So the first category are actions brought by employers attempting to vacate board judgments for failing to have workers' compensation coverage or judgments stemming from uninsured workers' compensation claims. So we had 12 such actions brought in state Supreme Court this past year. They generally take the form of an order to show cause seeking vacatur of the underlying judgment. However, this year, somewhat unusually, they also took the form of 2 Article 78 proceedings arguing that the underlying decision establishing liability was itself arbitrary and capricious. So the most common arguments that the board saw from employers when attempting to vacate judgments included not being served with process or provided notice that the judgment was going to be filed against them. The employer had no employees, and thus there was no requirement to maintain workers' compensation coverage in the first instance, or that the claimants/injured workers were not their employees to begin with. In these cases, we file opposition, obviously, and generally we rely on one of the following 2 arguments. The first one is that the board itself, the Appellate Division 3rd Department, and ultimately the Court of Appeals have exclusive jurisdiction to hear appeals of board decisions pursuant to Workers' Compensation Law Section 23. Thus, to the extent that any employer is attempting to vacate a board judgment in Supreme Court simply lacks a jurisdiction to do so in the first instance. Second argument, unlike a judgment filed pursuant to the CPLR, service of process is not required pursuant to Section 26 because prior to the entry of the judgment, the employer would have already had the opportunity to contest the validity of it in administrative proceedings that would have been commenced under either Workers' Compensation Law Section 52.5 or 23. So, of the 12 matters pending in Supreme Court in 2019, we have 7 of them still pending. 2 were abandoned by the petitioner/employer after receiving our opposition papers. 2 settled with the board, and in 1 instance, Supreme Court judge refused to even sign the order to show cause when we intervened very, very promptly and informed the court that it simply lacked subject matter jurisdiction. That case is a little bit nuanced. Interesting, the plaintiff was undeterred, demanded that the letter from the court denying the order to show cause be so ordered so he had an appealable document. He got what he wanted, and he's actually filed a notice of appeal to the 3rd Department, so we're going to be briefing that shortly, probably by the end of, or the beginning of next month. We also had 2 actions on the same type of subject matter brought in federal court. So we submit motions to dismiss, arguing similar type things. Court lacks subject matter jurisdiction, easy for me to say, under Workers' Compensation Law, Section 23. Our processes afford all due process that is required. But in a federal forum, we also have a couple of additional defenses. Sovereign immunity is going to bar the claims, and generally speaking, we can avail ourselves of something known as the Rooker-Feldman doctrine. So we had two of those. In the first case, plaintiff discontinued after receiving our opposition papers. Second case, the court dismissed all but a very, 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 very limited portion of a due process claim. There was literally a litany of claims being advanced by a pro se claimant. There is some perceived question as to whether or not the plaintiff had the ability to appeal the judgment given the unique facts of the case. As with other noncompliance matters, we're willing to explore settlement in terms of a reduced fine, but if not, we're fully prepared to move forward with discovery and proceed to trial if necessary. Second big category of actions that we see with some frequency are suspension of medical providers and/or licensed representatives. So Workers' Compensation Law, Section 13D, provides for the suspension and/or removal of a medical provider's authorization to treat injured workers, and the board exercises this discretion in appropriate circumstances. Section 24A and the attendant regulations have similar provisions with respect to licensed representatives. These cases are brought on as Article 78 proceedings by aggrieved former licensees/healthcare providers, and the standard review is whether the board's determination was made in violation of lawful procedure, affected by an error of law, or arbitrary, capricious, or an abuse of discretion, including an abuse of discretion as to the measure or mode of penalty or discipline imposed. So we had 3 of these actions in 2019. The first involved the board determination to remove a physician for failing to disclose prior restrictions on her medical license. This is actually overturned by Erie County Court. The court decision was not especially clear as to its basis, but given the limited nature of the order that resulted from that, litigation in conjunction with Office of General Counsel as well as Medical Director's Office made a tactical decision not to appeal the case further to the 4th Department. The second case involved a physician group challenging the adoption of certain amendments to the board's medical treatment guidelines after being served with the board's opposition papers, which included a change of venue motion and a motion to dismiss for lack of standing, mootness, and statute of limitations. Plaintiffs withdrew their petition with prejudice. Third action, physician challenged the board's decision to remove his authorization based on knowing false statements of material fact and professional misconduct. We answered. The board determination was affirmed by Dutchess Supreme Court. The petitioner requested re-argument that was heard and denied, and he's since filed a notice of appeal, and we'll be briefing that as well in the coming year. Third group of categories of actions that we find ourselves in virtually every single year are court of claims proceedings. So generally speaking, where there's a claim for actual money damages as against the state or one of its employees, the claimant is absolutely required to file a claim in the court of claims, and the claim is then adjudicated in that forum. And we had 7 active matters in 2019. Of those 7, they fall into 2 broad categories. First category are claims by or on behalf of claimants alleging improprieties in the handling of their underlying workers' compensation claims. And the second one, as you might imagine, are claims of personal injury that occurred on state and or WCB property. So with regard to the former, there were 4 filed claims plus 1 notice of intention to file a claim. So for the actual 4 filed claims, we filed motions to dismiss based on a lack of subject matter jurisdiction, i.e. if it's involving their actual claim, they should have taken an appeal to either us or the 3rd Department, and a failure to state a cause of action. You can't have a cause of action against our judges carrying out their judicial function, and respondeat superior bars liability to its state for errors made by the judges. We've been successful on all 4 of those, and the time to appeal those has since expired. So on the 2 PI actions, we filed a motion to dismiss on timeliness filed in the first one, and we're just waiting a decision on that one. In the second one, we answered, and we're actually conducting discovery. And this is because we believe it's not likely going to be a workers' compensation board issue, because we don't believe it was our site. It was somebody else's site where the injury took place. fourth big broad category are bankruptcies. So as a result of all the other stuff I mentioned earlier, we frequently find ourselves in a position of creditor relative to employers that have filed for bankruptcy proceedings. Depending upon the nature of the board's status, i.e. are we a secured or an unsecured creditor, or is there a priority claim versus a general claim, and the type of the bankruptcy, is it a Chapter 11 reorg or is it a straight no asset 7, we'll take various actions. Generally involve filing a proof of claim in the amount of debt owed to the board against the debtor's estate. Most of these resolve fairly amicably in the sense that the claim is accepted and we have a distribution according to whatever plan is being filed by the debtor. There are occasionally some disputes arising over the valuation of the claim or our priority. We were actively involved in 4 of those matters in 2019. There was one rather interesting one. It involved a Chapter 11 filing by a former individual self-insured employer. They filed Chapter 11 in Northern District of New York, and shortly thereafter commenced what's known as an adversary proceeding against the board, seeking to recover the security deposit that the board held as security for the self-insured employer's outstanding workers' compensation claims. So in the adversary proceeding, the employer alleged that the board is holding a security deposit of roughly $2.4 million. There's only 19 open claims, and that the reserve amount needed for the pending claims was only $1.1 million. Therefore, they were seeking to recover $1.3 million from us. So in this particular instance, we used the bonding authority provided in the 2011 legislation relevant to insolvent self-insurers to avoid a protracted legal fight over the true value of the claims. Working collaboratively, wow, that was good. Working collaboratively with the Office of the Attorney General, the Office of Self-Insurance, and the Department of Financial Services, the remaining claims were rapidly put out to bid to all licensed workers' compensation carriers so that the remaining liability could be transferred to a commercial carrier on an irrevocable basis. This had the effect of refunding a significant portion of the security deposit while at the same time ensuring that all claims of the former self-insured employer's employees would be paid. So really it was a win-win-win for the self-insured employer, the board, and all the injured workers. So, last category, miscellaneous catch-all category. So this is going to include stuff like the 2018 federal declaratory judgment action commenced by Verizon alleging federal preemption of the board's ability to adjudicate 120 discrimination claims. We had 8 of these active this year. So the first one was a claimant filing a complaint in the Southern District of New York alleging a violation of the 14th Amendment right to due process, a Section 1983 claim, and retaliation claims under the Americans with Disabilities Act and the First and 14th Amendments. We filed a motion to dismiss. It was dismissed. He requested a motion to reconsider. It's been denied. The time to appeal has since lapsed, so that's been taken care of. Second action involved a plaintiff employer filing an action for a declaratory judgment, naming the board, a claimant, and the claimant's employer as and carrier as defendants, alleging that a pharmacy should be permitted to seek payment of a prescription bill from the responsible party in a plenary proceeding in a court of appropriate jurisdiction. Both the board and carrier moved to dismiss the complaint. Board's motion was supported by subject matter expert affidavits, asserted that Section 13 does not provide the plaintiff with the right to seek payment in state court, and that adequate remedies are available within the confines of the workers' compensation system. The trial court dismissed the action on jurisdictional grounds. The plaintiff has since appealed the decision to the Appellate Division, 2nd Department, and we're awaiting decision, but it seems really to be a moot matter in light of the recent amendments we had in that particular avenue. Third action, a former workers' compensation examiner who was dismissed while on probation filed lawsuit against the board and supervisor alleging 1983 claims, violation of Title VII of the Civil Rights Act 1964, and violations of both the state and New York City human rights law. This matter was unusual. I mentioned unusual in the sense that it went all the way to trial. We actually had a 3-day bench trial. Court eventually issued a decision. Plaintiff was not entitled to relief on any of his claims. Plaintiff has since appealed, and the Second Circuit has affirmed, and it doesn't appeal, that he's going to actually try and seek certiorari to the United States Supreme Court, so that might put an end to that one. Fourth action, petitioner brought an action seeking an order enjoining the board from using digital audio recording as the official record of board hearings and compelling the board to create it and make available a quote-unquote stenographic transcript of proceedings before it. The board mooted this proceeding out by updating CIS functionality to allow for the claimants to print out their own stenographic minutes. That case is gone, done, taken care of. Fifth action, a federal postal employee served the board with an action against several doctors, but also named something called the Office of Workers' Compensation Programs. Very quick motion to dismiss, and the court agreed just last month that we're not a proper party, so the federal action will be going on, but it doesn't involve us any longer. Sixth action, Article 78 was commenced by a claimant claiming that the board improperly denied him benefits. We've made a motion to dismiss. That's pending. Seventh action involved in Article 78 alleging that the board did not properly respond to plaintiff's FOIL request. Petition was denied at trial level. Plaintiff appealed. The matter is brief, and we're just waiting for oral argument day at the Second Department. And the eighth action is a relatively new one. It's actually 26 separate actions venued in 9 counties throughout the state, and it's really rather quirky. What they are, in essence, shareholder derivative suits filed by the parent corporation of a subsidiary insurance carrier seeking recovery from the employers and their owners of funds paid by the carrier to the employer's injured workers, and the transfer of 1,060 claims, i.e. all of the claims of the employers, to the UEF on a going forward basis. Obviously rather problematic for the UEF to basically double their work or double the size of the fund itself. It's fairly convoluted, but in essence the corporation alleges that the employers in question disavowed the policies from the carrier as illegal, and they did this in the context of a predecessor action in Oneida County that the board was not a party to. And then they argued that the employers are therefore uninsured, and therefore the parent company should be entitled to seek to recover all payments made retroactively pursuant to Section 26. And then they take the additional step of suggesting that the claimants should be required to abandon their workers' comp claims and instead sue the employers directly under an election of remedies pursuant to Section 11, and that the corporation, moreover, should be subrogated to the funds that expended under a Section 29 lien theory. Lots going on there. So, moreover, the complaints included roughly 1,060 workers' compensation law Section 110A violations because it included an explanation of each of the claims. So we immediately engaged plaintiffs' counsel after being served with the suits, and after some vigorous discussions, we explained both the procedural issues. The bottom line is these are all in Supreme Court, and again, Supreme Court lacks subject matter jurisdiction over policy cancellation questions, as well as the legal issues. Basically what they're arguing is a type of a void ab initio theory, and there is no void ab initio in workers' compensation policies. It's fairly black letter law after matter of Cruz versus New Millennium. We've been fairly successful. Counsel immediately moved for a protective order expunging the 110A material, and then moved for coordination of all 26 actions by way of a motion to the litigation coordination panel. The motion's filed and the matters have been sealed. The most recent development is the board and the Office of the Attorney General are going to be, because we really take no position as to where we agree that coordination is appropriate, if for no other reason to allow us to file a single motion to dismiss as opposed to 26 of them, so we don't necessarily care what venue that's in because the outcome is going to be identical. We're going to be putting in a very brief attorney affirmation to that effect, that we take no position with respect to venue of the coordinated matters, as the entire cases should be dropped as against the UEF and the 1,060 claimants, which plaintiff's counsel has informally agreed that is going to be his first order of business after they are in fact coordinated. So that was an awful lot of talking rapidly.
Oh, good job.
Great job.
Do any of you have any questions?
Not busy this year, huh?
Yeah, right here.
And that's just one of the divisions that he heads.
Well, if you guys don't have any additional questions, that'll conclude my remarks, and I'll turn it back over to Clarissa.
Okay, thank you
Thank
so
you.
much,
Thank
Mike.
you.
Yes, we do keep him very busy. Well, before I adjourn the meeting, I just want to wish everyone a very happy holidays and a safe and joyous start to the new year. And with that, may I have a motion to adjourn the meeting?
Move to adjourn.
Okay, second. All in favor?
Aye.
All opposed? I am also a yes. Meeting adjourned. Thank you so much.